because this particular lecture is with regard to your legal aid. So here the question arises that who in Hindu law is a prohibited degree. Basically talk about, we say that lineal ascendants in our prohibited degrees. Lineal ascendants, your grandfather, your grandmother, great-grandfather, great-grandfather, or your lineal descendants, your own children, your grandsons, your great-grandsons, all are there. Then they talk about wives of your lineal ascendants and descendants. Wife of your lineal ascendants and descendants. That means, let's suppose your grandfather marries a second time. A person's grandfather marries a second time. Now she might not be your grandmother, but still she is in a prohibited degree. Still she is in a prohibited degree. And why we recognize that? Because on these bases we want to identify whether the marriage is valid, void or voidable. That's a question if somebody, because in our Indian society, things are complicated because of relationships, right? Family law applies to relationships. So we have to be very clear about relationship. Again, but there is, with all these exceptions, that if your customs allow it. If your customs allow it, you can marry anyone you want. Normally, your cousins are your prohibited degrees. But in our south, you can marry your own uncle or your mother's side relatives in South India. So again, it depends upon the custom. In North India, you cannot. In North India, two cousins cannot marry because they belong to prohibited degree. Similarly, in North India, you cannot marry your brother's widow, apart from few communities which allow it. So you have to understand that, and these are given in your section 2. So whenever first a case, sometimes when case comes in with relationships involved, you look something this, whenever you are setting this should always you have it. Always. Because however good you are, you cannot be very, sections can change, also teaching interpretation, you can interpret things very differently. And now I tell you how you can take things of interpretation too regarding your family law also. Next is your half-blood and stepbrothers. There's a whole lot of difference between half-brother and stepbrother. Why? Half means that you share a parent, either a mother or a father. Whereas step means that you don't share anyone. There is no blood relationship between you. It's a step relationship. Your mother marries somebody else's father, that's a step relationship. Whereas when you share either a father or a mother, you are half-blood brother and sister. Yes?
Uterine blood.
That means if mother is sharing is a uterine, if its father is consanguine. I'm not going into terminology because it will be difficult for you to remember all these things. Similar to have simpler terms like half-blood. He's a half-blood if you share same mother or if you share same father. Stepbrother, when you don't share neither the mother nor the father. This difference, always remember, marriages between half-blood are void. Marriages between step relations are valid. Okay, marriages between half-blood, void, not allowed. Illegal in India, immoral in India and void also. Whereas marriage separation, accepted, valid marriages. Okay, the next is your customs and ceremonies. There's a whole, yes. Okay, half-blood and stepbrother. Simple example, let's take it. A marries, I'm sorry, one sec. Okay, let's take an example. Let's suppose A marries B. Okay, A marries B and they had a son C. Okay, they had a son C. Now B dies. B dies and A again marries D. A again marries D. Now they have a daughter E. In this C and E are half brother because they share one parent, because this might be a mother, this might be, let's suppose this is mother, this is father. Though they share the same father but different mothers. So they are half blood. They are half blood relationships. Whereas when we talk about, let's say talk about step means A had a son D, marries a woman B who has a daughter C. Now these two people are step brother and sister. If they want, they can marry each other and it will be a valid marriage. Okay? Clear?
Take the second example.
person, let's suppose X, they had a son, B. Okay, B again married a person Y, they had a C. X dead, Y dead. They both marries again. He has a son already. She has a daughter already. Now these two people are step relatives to each other. Ye step dad hai, this is step mom. They are step brother and sister. Here they can easily marry. Not otherwise. If they are sharing a parent, they cannot. Current example, Indrani case. Okay, Indrani's daughter from first husband and son from the third husband. They can obviously marry because they don't have a blood tie to them. You know, you might scorn upon to find your race like a brother and sister who's getting married. That might be possible. But legally, morally or ethically, you can scorn upon them. But legally, they are doing nothing wrong. Okay, now it's clear? So why we say that these things are important? Because these are the technicalities where a person can, declare marriage voidable or valid. The next is customs and ceremonies. There's a difference between customs and ceremonies. You all have now studied because you first also know what exactly is a custom. Custom means yes.
So are relationships between blood marriage void or
void? They are void. When you come to marriage, no, they are void. We study about the 3 kinds of marriage. Also, we have few more words left. Now I have a shortage of words, so that's why I don't need 6 words. I'll give you more words to void, voidable and valid. What kind of those are, okay? When you talk about customs and ceremonies, why I spell them differently? Because in our Hindu law, what are important for a marriage are ceremonies, not customs. Okay, in Hindu laws, this is your section 7 of the Act, which says that for a valid Hindu marriage, a person should undergo certain ceremonies, never certain customs. So these 2 words, though we say that, if you talk about what kind of ceremonies in a Hindu marriage is there, Kanyadan, Panangrahan, all those things you must be aware about, though they can be also regarded as customs. But when those customs become ceremonies, it's basically 2 things. In Hindu law, basically, custom becomes a ceremonies when they have the legal sanctity. Certain customs also have legal sanctity. We have already studied that, we all know that what are valid customs. They should not be opposed to law, they should not be opposed to public policy, they should be ancient. Whereas ceremonies need not be ancient. With ceremonies need not be ancient because ceremonies can be recognized by law. In a sense, I'll give you an example also. After in your South India, there was a strong discontentment with regard to involvement of too much Brahmins in the marriage ceremonies. Okay, so what they started like a simple ceremony where just exchanging of garlands in front of few people will result in a valid marriage without having any long days, everything else. Now this was not an old custom, but how this marriages become valid? They were given by an act. An act was given to them. That's why those ceremonies were incorporated in the act. Whereas to validify a custom, you don't bring an act. Custom has to be proven as ancient. Custom has to be proven as continuous. Custom need to be proven as not opposed to public policy, not opposed to law. For custom, you don't break laws. Okay? Clear? Next is this is something as in, when you're going to take it, there's 2 things. Maintenance as ancillary relief and maintenance as maintenance. Maintenance as ancillary relief means that whenever there's a divorce, proceeding, a wife is entitled to maintenance. Right? You all know that? Or the husband is also. When we talk about ancillary relief as maintenance, we are actually talking about Hindu law, specifically section 24 and 25. When we talk about ancillary relief as maintenance, we are specifically talking about section 24 and section 25. What exactly those sections are? They basically say that whenever there is any kind of discord in a marriage relationship or any kind of proceedings under the law, basically Hindu law, example, restitution of conjugal rights, or your divorce proceedings, judicial separation. In this regard, either of the parties, again, another feature of your Hindu law is it's gender neutral. It never says wife can claim. When you talk about ancillary relief, it's available to both husband as well as wife. In India, again, because of the condition and everything else, we say that only wives are given. Husband, there are few cases. If you really go into, there are only 3 cases. Till now, 3 cases where husband has been granted maintenance. Where with wife, we have the third of cases, obviously. So, whereas we talk about maintenance, maintenance is not always corollary to divorce. A wife can also demand for maintenance. In a sense, a Hindu wife, when she is being married, her marriage is subsisting and her husband is not maintaining her. Maintaining means not providing for her food, cloth, shelter, medicines or anything else, she can still claim maintenance. It does not require she has to file a case in the law, okay fine, I want to be separated from her, or I want us to conjugal rights. Nothing like that. She just needs to say, I am a wife and I need to be maintained. That is a privilege given to her. Again, what we regard as protective discrimination. Again, because your whole of your family law is your remedial statute. It is for basically a social welfare legislation. For welfare of a vulnerable group, that is particularly women and children. The basis of your Hindu code bill, if you go into the history, was to actually ameliorate the position of women and children in families. That is your basic, if you read the law, if you read the Hindu code bill, the statement SOR, is to ameliorate the position of women and children in families. Women and children should be given certain rights. Clear this part? Again, now few words, void, voidable and valid. As a law student, we must have heard this. Another thing, when you talk about a marriage cannot be illegal. A marriage cannot be unlawful. A marriage, it has to be either void, or any kind of those words. If a law student, you have to say either a marriage is void or voidable or valid. No other substitute can be there. Being a law student, remember that terminology for you is very important. One person can say this marriage is illegal. You cannot say it. There is nothing called as illegal marriage or unlawful marriage. Like an unlawful conjugation can be there, but it can be unlawful marriage. Okay, so remember, when you're talking about a marriage, it's either valid, void or voidable. Never forget that. Now, what are valid marriages? Obviously, which conforms to all the conditions prescribed. I'll tell you those conditions in just a while. All those conditions, if are fulfilled, the marriage is valid. Void, when those conditions obviously are contravenes, then it's a void marriage. Voidable, when voidable basically implies that it is valid at the option of one party, right? The marriage is valid until unless the party who is not at fault, contest that my marriage is voidable because of these reasons. For a void marriage, you don't have to go to a court of law actually to make it. You don't have to give a petition as such. Normally you gave petition for the purpose of law and everything else, if you have validly got married. So obviously you should have a proof that okay, my marriage was void. That's the reason. Otherwise, void marriages, example, you married between your prohibited degrees. You married your cousin brother. That marriage is void ab initio. You don't need a proof to say that it's a void. In these days, we do that. We do that for the purpose of society. That later on it's not created, a problem is not created. But with voidable marriage, a petition has to be produced, given, and then you have to prove it that your marriage is voidable and why are this marriage voidable. Valid is again there. Let's start with marriage. This is clear? Clear? Now let's start with marriage. The marriage is your section 5 of your Hindu Marriage Act. This is very important. It contains 5 conditions. It has 5 conditions in which conform, if you conform to it, your marriage is valid. If you don't, then your marriage is either voidable or void. Not per se it becomes void. If एक भी condition conform नहीं तो void marriage होगी. No. It's either voidable or void. Now first condition is that if you have any, that is bigamy. If you have a spouse living at the time of marriage. If either of the parties have a spouse living at the time of they were contracting the marriage, it will be regarded as this marriage will be a void marriage. In India, bigamy is a criminal offence also and matrimonial offence also. Okay, every time an offence which is matrimonial does not mean criminal. But bigamy is such an offence which is criminal as well as matrimonial. Similarly goes to adultery. It is criminal also, it's matrimonial also. Okay, so here bigamy is a criminal offence and a matrimonial offence. offense. What is wrong with bigamy? Second wife not entitled to maintenance. The biggest problem. If a woman is a second wife, she is not entitled to maintenance. Recently, you must have read about live-in relationships. A second era is coming in, and what about the live-in relationships? Now, live-in relationships is nowhere recognized under our statute books, but they are recognized by virtue of case laws or precedents. Starting from 2008, Bharat Mata versus Union of India, decided in 1997 in Allahabad High Court, in 2008 by Honorable Supreme Court by Justice Markandeya Karju. That was the first case, Bharat Mata versus Union of India. Then there are plethora of cases which come and go, and till now we are using more and more cases. We are not going to cases, I am just giving you case law because what I have been given is 50 minutes to teach you entire marriage, divorce and maintenance. So that's why I am, now I am actually going to the speed of Shatabdi. Okay, so let's start again. First is bigamy, which is an offense, criminal offense as well as a matrimonial offense. Any person having a living wife or a husband, contracts a marriage, that marriage is void ab initio. The second clause contains three things. It says that a marriage will not, a person cannot give a valid consent. Very important thing in a Hindu law is that it does not talk about free consent. Very important thing that our Hindu law never talks about free consent. In a sense that in a marriage contract, even if a consent has been obtained through fraud and force, on the face of it, the marriage is valid. Even though a consent has been obtained by fraud, force, coercion or any other means, on the face of it, the marriage is valid. After a time, a party can prove it. My consent was obtained through medium of fraud, force or any other medium, which is not coercion, and then can annul the marriage or avoid the marriage. But on the face of it, our Hindu law does not talk about free consent. What it talks about, vitiating consent, in a sense that it won't be taken as a valid consent if a person is suffering from insanity or unsoundness of mind. Again, your unsoundness of mind is different from what your unsoundness of mind should be dealing criminal law. Criminal law and this law, the unsoundness of mind is different to an extent. To an extent, it's quite different. The second is impotency. Why I say that interpretation becomes very important? Because there's a long debate that your actually section 5 uses for certain words. It says that, it very simply says, capable of giving a valid consent has been suffering from mental disorder of such a kind. Through capable of giving a valid consent has been suffering from a mental disorder of such a kind or to such an extent as to be unfit for marriage and procreation of children. Here what the court have been bombarded with, if a person is sterile, then again he is not fit for procreation of children. Here the court said, here you have to read it unfit for marriage and procreation of children. That means first it should be read in conjunction, not singly. Ki fit for marriage hai lekin procreation nahi kar sakta. The person should also be unfit for marriage. It has to be read in conjunction. And why do we use the word and here, not or? Because we want to connect the both dots, right? When we use the word and, is to bring two things together. When we also say this or that, we use the word or. That means using the word and here, the legislature have a specific intention. That means if a person is sterile, or if a woman is sterile, you cannot divorce her or you cannot say the marriage is not valid because she is sterile. She cannot procreate children. It's not like that. Unfit for marriage and procreation of children. So basically what we covered here is impotency. Physical as well as mental impotency. What actually your clause 2 of clause 2 of this subclause 2 talk about is physical as well as mental impotency. There are cases of physical impotency also and mental impotency where everything is fine but still a person can be regarded as unfit for marriage. The third is your recurrent attack of insanity. Recurrent attack of insanity, that means a person might be, for if you meet a person, he is completely normal. But one fine day he becomes aggressive, started throwing things. So a recurrent attack, that means on a 30 days or 30 days of a month, 10 days is fine, 20 days he is suffering from some kind of other disorder. Example might be possible, there can be different level of schizophrenia. They can be different level of depressions. They can be different level of bipolar disorders. A person might be suffering from BPDs, but the effect is like twice, 3 or 4 or 7 years. One time he has this disorder. One time he's suffering from that particular recurrent attack, this attack. And might be possible, it's a simple schizophrenia, but after every 3 days he becomes delusional. He or she becomes delusional after every 3 or 4 days. So you have to distinguish in that. That's why I said, difference between what you regard as insanity under your criminal law and insanity under your family law or Hindu law, because again you have dealing with the human emotions in it. So you have to specify this side. A person having a low IQ cannot be said to be an unsound person. A person having a low IQ, हम कहते हैं low IQ है ट्यूबलाइट है यार, but वो ट्यूबलाइट को आप ये नहीं कहते you cannot get married or your marriage is void. Fine, a person might be having a low IQ, or a person's social intelligence might be low. There is a strong, actually, psychological debate going on that in today's era, our teenagers are having a low social intelligence. Why is low? That means, it doesn't mean lower social intelligence doesn't mean they are insane. Lower social intelligence can be of different because of the current more interaction with your phone, with your iPad, with your laptop than with actual people. Obviously, that result is low social intelligence. These are different scenarios. I am not saying that everyone is. The different reports. So that means low social intelligence is not equivalent to insanity or unsoundness of mind. So you have to distinguish between that. That is the most important thing. The next is we all know about that. Bride should be 18, bridegroom to be 21. With regard to section 2, the marriage is again voidable, not void. In first case, if the first case is not fulfilled, if a person is committing bigamy, the marriage is void. In second case, in case of unsoundness of mind, physical or mental impotency and recurrent attack of insanity, the marriage is voidable at the option of other party. At the option of other party. Not the party who is important cannot say, no, I want to annul this marriage. It's from the option of the other party. Because he has been wronged in this regard. The next is your bride should be 18, bridegroom to be 21. Again I want to say no. Absolutely wrong.
Valid.
The marriage is valid. Under Hindu law, the marriage is valid, not even voidable. It is your Child Marriage Restraint Act 2006 which make it voidable, not void. That is the biggest lacuna in your law. Child marriage in India is nowhere declared as void. It's a voidable marriage. Remember that. It's a voidable marriage under your laws with regard to general laws, and with regard to Hindu law, it's a valid marriage. It's punishable under section 17 of Hindu Marriage Act. It's punishable, but still a valid marriage. Remember this. Child marriage is still valid in India because this law is still there. Because if we talk about what kind of marriages are void and voidable, it is declared under your section 11 and 12. And section 11 and 12 nowhere talks about child marriages. It is silent on child marriages. So something which is silent, that automatically implies it's valid. Right or wrong?
Yes.
If they are specifically said कि bigamy void, insanity voidable, impotency voidable, recurrent attack of unsoundness of mind voidable, and with child marriage complete silence, what do you take it? It's a valid marriage. Okay, the next is you cannot marry with your prohibited degrees. I talk about prohibited degrees. All the list is given. You cannot marry your grandmother, grandfather, step-grandmother or step-grandfather. You cannot marry your step-grandson or step-granddaughter, grandson's wife, or step-granddaughter or step-grandson's granddaughter's husband. All your lineal descendants, you cannot marry your uncle or aunt. You cannot marry your brothers and sisters. That is your first cousins. You cannot marry your first cousin. This is given in your prohibited degrees. The next is the last is your Sapinda relationship.
Ma'am, this prohibited degrees marriages are void ab initio.
Yeah, they are void ab initio. There are 3 marriages which are void ab initio. Bigamy, that is your section 11. Section 11 talks about 3 kinds of marriages which are void ab initio. First, bigamous marriage. Second, marriages between prohibited degrees. Third, marriage between Sapinda relationship. Now with Sapinda relationship, I cannot teach you right now. It's next to impossible. It's next to impossible because in my 4 years of teaching, it was not possible to explain it in 3 lectures also. So how can I explain you here? So just take Sapinda relationship marriages.
S.
I can get the spelling actually. Sapenda. Sapenda ये तो है गड़बड़ की क्या? I तो है. अच्छा हाँ sorry. SAPINDA. Sapenda. That is the 5 conditions required for a valid marriage. First, let's repeat fastly. Bigamy should not be there. First 5. Second, the third 5 under 3 parts. Unsoundness of mind, physical or mental impotency. And third is insanity. That is your recurrent track of insanity. Bride 18, bridegroom 21. No marriage between prohibited degrees. No marriage between Sapenda relations. Okay? That's it. This is your section 5. Another very important is your section 7. That is your ceremonies of marriage. We have already prohibited the Sapenda relationships. Make your marriages void. If a person marries within the Sapenda relationship, the marriage is void ab initio. It's voidable in case only of your insanity. Other conditions I'll give you what are the voidable. Void. Void we have covered. 3 bigamous prohibited and Sapenda. Otherwise, in Hindu law, no other marriages are regarded as void marriages. No other marriages. Apart from these 3, no other marriages are void marriages. Again, an exception is your ceremonies with regard to marriage. What do you mean by ceremonies? There can be 2 kinds of ceremonies. That is your Shastric ceremonies or तुम लोग क्यों बैठे हो यहाँ पे? धार क्या है? क्या होगा? There are 2 kinds of marriage. The first is a Hindu marriage may be solemnized in accordance with the customary rites and ceremonies. जो मैंने अभी बताया, customs and ceremonies. Customary, in fact, there is a strong custom in your chart that is chadar andezi. If you cover a woman with a red, take a red chunni and cover a woman's head, the marriage is complete. That's a custom, and it's a valid custom and a loud custom. They do it to basically to widowed. The women who are widowed, they get married to their brother, their husband's brothers in this fashion. It's a valid marriage. You cannot say, okay, there was no, all those rasmes and kasmes, no matter for that. Or they can be different. Like in Buddhist, there are no ceremonies at all. Buddhists have no ceremonies whatsoever. You cannot say that for a Buddhist marriage, this has to be there. For a Hindu marriage, and now we come to the second, that's just Shastric ceremonies. Between there are lot of Shastric ceremonies. When the, earlier we used to say dowry was also a Shastric ceremony. Now, obviously it's not a Shastric ceremony, or Pani Grahan, or Kanyadan, or a lot of, there are 5. The most important are only 2 things. First is your Satpati. That means 7 peras around the holy fire. Lighting that holy fire is again a ceremony, and that Satpati is again a Vivah Homa, that is called as. Vivah Homa and Satpati are only essential ceremonies required for a valid Hindu marriage. Even though, yes.
Ma'am, could you please repeat both of those?
Vivah Homa and Satpati. That is your 7 peras, and Vivah Homa is lighting the holy fire. If there is a holy fire, now again we all say there has to be an intention to marry. That is very important. There has to be an intention to marry. Right now, यहाँ पे कपड़े डाल के करके सब घूम ले, तो शादियाँ नहीं हो जाएगी. Obviously, there has to be an intention to get married. An intention, though presence of a priest is not an essential ceremony. If there is no priest, then also there can be a valid marriage. Why do we have all these things? It's basically because we regard, in Indian society, we regard marriage not only a religious, but a social ceremony also. Right? So this is for social society. We want to see people come and see, okay, fine, this one is marrying this one. No, all those things are required. So this is the only reason. Otherwise, a marriage only requires 2 people and an intention to get married. 2 people and intention to get married. Again, because of the, now a lot of people can have intention to get married at that point of time, and later on ran away. So that is why again we have a new reiterate concept that registration should be there. Though we do not still have compulsory registration in India, your Hindu law talk about section 8 in India still because states are not ready. Though there has been a very important judgment, Seema Kumari versus Union of India in 2006.